Hello, I am Courtney Lytle. I will be your sole panelist today. We're going to be talking about copyright. I think our title is Copyright 101. So this is a very kind of basic level, what copyright is, what it isn't, what it can protect, and we will have time at the end to answer specific questions that some of y'all may have. Usually the folks who are most interested in coming in here and learning about copyright are ones who have something they're thinking about copywriting. So I can give you some good information, practical, brass knuckles level, what you need to do and not do to protect whatever it is you're creating. And and then at the end, I'll take specific questions. If we run out of time, I'm happy to wait after if you have very specific, I have this thing, I want to ask this very specific question that no one else cares about. I have time afterwards to answer those as well, and I'm happy to do so. I'm a IP lawyer. I'm a partner at Culhane Meadows. I teach at Emory Law School, and some friends of mine in other areas of practice go and do pro bono work, helping criminal defense stuff and bankruptcies, and I'm a copyright lawyer. I'm like, great, I can help people register their copyrights. So I kind of think of this sort of as some pro bono work. I can get some good information out to you guys that is very expensive if you have to pay a lawyer to tell you. And one of my kind of crusades is to give you guys good information, because most of what you can reach on the internet is garbage. You may be shocked to hear this, but not everything you read on the internet is true. I'll take a second while you recover from that. It's shocking, I know. No one expected to hear that, but it is true. Now, as a copyright expert, I can read even the well-written stuff and tell what's correct and not, but it's taken me a lot of years to learn all this crap, and you guys haven't had to do that, so I will tell you instead. But as a warning, a lot of what you have read online, especially about fair use, even the stuff that's written well and has some truth in it and understands the law well, the majority of the stuff out there that's readily accessible when you look online, the stuff that shows up first, is written by advocates. They have an axe to grind. They believe that the law should go a certain way. They want fair use generally to be expanded, and they are giving you information towards that end. It's not necessarily going to be helpful for the position you're in, and I try to kind of counterbalance that when I talk to folks about this. So that's kind of where I am coming from with this. I'm a transactional lawyer. I don't litigate, so I'm not going to try to tell you how to win your lawsuit. In my world, success is when you don't have a lawsuit. Lawsuits make litigators rich. Sometimes the plaintiffs get some money too, but it's usually a long road. So as a transactional lawyer, I make deals, I write contracts, and we try to avoid going to trial. Now, we'll set it up so that if you do go to trial, the litigator will have good stuff to use to win, but that's not usually my goal. So that's kind of where the information I'm going to give you is coming from. Some of what I'm giving you is just Copyright Basic 101. We'll start with that. When we talk about copyright, the more generic term is intellectual property, which is kind of contrasted with real property, land, dirt, buildings, with tangible property, chairs, things like that. And then intellectual property is a specific sort of intangible property. With under the umbrella of intellectual property, we have copyright, which is the best. That's why we're talking about it. You also have patents. How many of y'all are actual sciencey people? Okay, you're smarter than I am, and patents may be relevant to you, but in order to be a patent lawyer, you actually have to take science classes. Most lawyers didn't. There are people who can do both law and science. Those are the patent lawyers. If you have an invention, if you have come up with a machine, a pharmaceutical, a process, something practical and useful and fabulous, you need a patent lawyer. I'm not one of those. I'm not nearly smart enough to be a patent lawyer. I took astronomy for my required science in college. I sat in the back with a bunch of football players. So the biochem stuff, yeah. But patents are very difficult to file for. They're very expensive. If you are that person who actually has invented something that you think might be patentable, I can answer some basic questions about it. If you do, though, you'll need a patent lawyer. My one piece of advice is ignore the folks who tell you a patent agent is good enough. If you've invented something really cool and it's really worth filing, get you a patent lawyer. That's all we're talking about for patents. Trademarks kind of overlap copyright from time to time. Trademarks are any kind of name or logo or indicator that identifies the source of a good or service. I have my little thermos here. Where did I get my thermos? Buc-ee's. It's kind of replaced Disney as the happiest place on earth, hasn't it? So you know where I got my thermos. Now, the nice thing about this thermos is you don't know what's in my thermos, but you know where I got it. That's a trademark. The Buc-ee's trademark tells you where I bought the thermos. If I had a red can with a white swoosh, what am I drinking? Coke. Y'all knew that. If I had a bottle that was a strain, they call it a pinch-shaped bottle. Let's be real. Cool. It's a woman-shaped bottle. If I had one of those in my hand, again, you would know I was drinking Coke because the shape of the bottle identifies the source of the good. So trademarks are your names. Nike, Adidas, any of the name brands. It's the logo, the swoosh, the Coke swoosh, which is different from the Nike swoosh. It can be sounds. It can be smells in some cases. It can, in certain circumstances, be just a color. The traditional case, the one that kind of broke that open and made it possible, any of y'all who own homes know about insulation, that really itchy fiberglass insulation that makes you itch just thinking about it, never mind rolling it out in the attic. If you bought some that was pink, it was made by Owens Corning because there's no reason for it to be pink, except that they brand it that way. Did you try them yet? So anything that is a color that identifies can be enough. It's unusual, but it can be. So that's trademarks. It's very different from copyright in that it's brand identifiers, and think about it more as a Consumer Protection Act. It's so that when you buy something, you're getting what you think you are. And in spite of how much value trademarks have, the whole point of the law is for your protection. I mean, don't get me wrong. Coke protects their trademark because they get a lot of value out of that trademark. But the trademark law itself is actually protecting you, not Coke. Don't tell that to Coke. It will make them all unhappy. The whole red tower down the road will start crying. But it'll just be our little secret. Okay, that's trademarks. We're not really talking about those, although trademarks can overlap with copyright. You may have heard of it's a logo, it's a character. You may have heard of it, Mickey Mouse. A few of you have heard of that. Now, what company is that associated with? Disney. We all know that. What a great trademark. Now, you've also heard that Steamboat Willie went into the public domain, so now Mickey Mouse isn't protected. That's partially right. When Steamboat Willie went into the public domain, the copyright for that little short cartoon was gone. So it's no longer protected by copyright. Mickey Mouse, the modern version of Mickey Mouse, has more recent copyrights. You can't use Mickey Mouse Clubhouse from 20 years ago. You can't use the Mickey Mouse Club from however many years ago that was. You can't use whatever the more modern version of that is, because those are all still protected. Just Steamboat Willie is unprotected by copyright. And even if the rest of them weren't protected by copyright, versions of Mickey Mouse are a trademark registered by Disney as well. So they do overlap. Don't get all excited when someone says, oh, Mickey Mouse is in the public domain. No. Steamboat Willie is in the public domain. And only as the standalone video or character itself, not as the representative of Disney. Representative of Disney is a trademark, individual cartoon, copyright. Now, copyrights, since we've now done away with the others, copyrights protect creative expression in pretty much any form we can come up with, and indeed ones we haven't come up with yet. When we started, it was books, maps, and charts. That's it. We've expanded a tad since then. But copyright is protecting your expression, your creative expression of an idea. So if you write a novel, great. The novel will be protected by copyright. If someone else writes a similar novel, doesn't copy yours, just writes a similar one. I don't know, if you come up with a novel where you have your protagonist is a young young man on the cusp of manhood, frustrated with living in a backwater nowhere. A couple strange things start to happen. Over time, he discovers that he has some powers and may actually belong somewhere other than the rural place that he's been raised, usually with an aunt or an uncle, but he's an orphan. Which book is that? Which story is that? Harry Potter. Yeah, all of you are right. It's a whole bunch of different stories. As I start adding more details to it, if I start adding droids and speeders and lightsabers, well, now you know where I am. If I start adding British schools and a sorting hat and strangely flavored jelly beans, well, you know where I am with that one too. Or I can go to the assistant pig keeper, and some of you also remember that book, Superman. Gosh, that's even similar, isn't it? So there's lots of those. So the idea of young orphan doesn't know who he is, discovers he's special, saves the world and or universe. Well, lots of people have written that story. We keep reading that story because we like that story. On some level, it engages us because all of us want to be that special person. I'm still waiting for my Hogwarts letter. It's a couple years late. But we all like that. And it's a great story. And that's why we read it over and over and over, because each time we like it. But that idea of the story is not protected. The detailed expression of that idea. Harry Potter, Star Wars, what was the Alexander one that I talked about, the assistant pig keeper? I just lost the title of that. Anyway, all of those different stories. No, it's not Black Gold, it's a different one. Any rate, all of those stories are copyrightable because they are original expression of an idea. If I want to paint something, well, I'll wish very quickly that I had any talent whatsoever. But if I were to paint a beautiful sunset, I am expressing my idea of what that sunset looks like, bounded by my limited talent to do so. Even if I had talent, the fact that I've done that does not preclude any of the rest of you from going out and painting a sunset. It doesn't stop you from going and setting up exactly where I was and painting the same view. It's even more interesting when I say that, interesting to me. Now you have to understand, interesting to a lawyer, especially one in academics, is we use that word differently than y'all do. It's just pretend it was ironic and we'll move on. But more interestingly is when we talk about cameras. If I go and take a picture of, I don't know, looking up in a hotel nearby and seeing all the weird curvy stuff in the elevators going up and down, I take a really cool picture of that panorama. Does that mean no one else can take that picture? Of course not. You've seen 1,000 pictures of that, and there haven't been 1,000 lawsuits. So anyone who wants to can go take that same picture. What they can't do is make a duplicate of my photograph. They can go take the same picture, but they can't make a copy of my photograph of that. So the idea of taking that picture is not protected. The photograph I took of that is my expression, that is protected. Even though with a camera, I'm just making a mechanical reproduction of it. That was a long battle that lots of academics made lots of bank on, fighting about whether a camera should be included in copyright or not. It's the kind of thing that we get excited about. Every time there's new technology, a lot of lawyers and academics get all riled up and fight it out. Then they decide what it is and we move on. Cameras, they count. In case you're interested, piano rolls for a player piano, those also count. That was a big fight. Albums, those can count. We now have copyrights in sound recordings. It's an old-fashioned term, we still use it because we're lawyers, we don't change. We don't like change, it frightens us. So we have sound recordings. But if you think about it, when we started having copyrights at the beginning of our nation, we didn't have sound recordings because we didn't have anything on which to record. We had sheet music. So any expression of creativeness is going to be protected by copyright. Some things are excluded though. Those things are facts, ideas, functions. So if I know something clever and I write about it, I'm no longer writing fiction, I'm writing nonfiction. The nonfiction facts or inventions or anything like that I put in a book or however I want to express it, the facts, the useful items in there are not going to be protected. If I write a history book and I've discovered really cool things, I discovered that George Washington actually had all of his teeth and was allergic to cherries, and I could prove it in ways because I did something clever and dug up a corpse illegally. I can write that book. You can read that book and go, wow, she should be in jail. I wonder who she knew so that she's not. But okay, that's interesting. I'm going to write a book about George Washington, put that fact in there. Copyright didn't stop you from doing that. Copyright stops you from copying my exact words, but it doesn't stop you from lifting those interesting facts out of my book. I don't own the facts. Copyright doesn't protect that. Okay? The classic copyright case, a guy who invented a new method of bookkeeping, dual column accounting. Let me tell you, the book is as exciting as it sounds. Several of his friends bought the book, and one guy bought the book, or maybe was given the book or found it used, and said, this is brilliant, and wrote a better book with the exact thing that this first guy had invented. May not be ethical, may not be nice, but he didn't violate copyright. Because he didn't copy the words, the expression describing it, he copied the system and described it himself. Okay? So those are some of our kind of outer bounds of what copyright covers and doesn't. Now there's the magic language for what will be protected is copyright covers an original work of authorship fixed in a tangible medium. Now, original does not mean no one has ever seen anything like this before. Original means it owes its origin to the author. And in fact, if I somehow create an identical work, if I have been living under a rock for the past 30 years, which sometimes I think I have, and while I was there, I started writing, and I wrote Harry Potter. I'd never seen the book, had no idea it existed, but I wrote Harry Potter word for word. If I honestly created it myself and didn't copy hers, it would not be an infringement. Independent creation does not violate the copyright. Think of it as the right of copies. I didn't copy it, I created it. So a lot of things that are very similar, as long as they're not copied from each other, can all be registered. There is no comparison of what's already out there when you register a copyright. If you try to file a trademark, oh yeah, they go and check to make sure no one's using those words or that picture or anything confusing. Confusingly similar is the phrase for trademarks. If it's a patent, they're supposed to do a really comprehensive prior art search, which means basically going and looking for anyone else who has already figured this out. In copyright, they just say, okay, did your check clear? Yes, you're registered. That's it. That's the background check. So very similar things can be protected and not be infringing, only if you violate someone's right. And the rights that you're given as a copyright holder they're in the statute. The ones that people normally care about are the right to make a copy, the right to publish and distribute, and the right to make a derivative work. Derivative work we talk about with respect to fair use, and we will get there. But I want to kind of push that one aside. The rest of the rights are like public performance and things like that. So if I create a dance, or I'll go with my book again. If I create a book, I write a book. If I transform it into a screenplay, the screenplay is a derivative of that book. I have the right to do that. If I write a sequel, also derivative. The author has the right to do that. If I want to publish it, I probably need to get a publisher, but I can grant the publisher the right to publish. All of those rights I have in my brilliant book. I'm still looking for a better analogy. I have yet to come up with one. So I have a bundle of sticks. Yeah, fabulous, right? A bundle of sticks. That's my copyright. And I can give my publisher the right to publish the book. Now, if I want to, I can also give her the right to publish ebooks. I could give her the right to make movies if I think she'll get around to it, but I may not want to. I can determine what rights relative to my book I give away. If you are signing with a publisher, that's something you want to know. If you're signing that contract, make sure you know what's in it, because the law doesn't describe what rights the publisher has. Your contract does. I have people ask me all the time, oh, I signed it, I got an agreement with the publisher, it's great, I'm published, woohoo, and I want to know what they can do, and then when am I allowed to do something? I'm like, well, what does the contract say? Like, oh, I don't know. Strike one. Well, I just want to know what the law says. I'm like, well, the law says, what does the contract say? Because the contract's what's going to describe which of those rights you gave away. Because you can give all, none, or a few. And what is in the contract is going to determine that. So no matter what kind of creation you're coming up with, if you're licensing it to someone for distribution and sale, read the contract. If you don't understand what's in it, ask someone who does know. Ask a lawyer. You can ask the other side, but they may or may not know. They may or may not tell you the truth, depending on the situation. Sometimes they will tell you lovely things like, oh, well, we never enforce that. Don't fall for that. We never, oh, well, then you won't mind if we just strike that out, will you? Oh, well, no, we can't do that. I'm like, yeah, that's interesting. If you never enforce, no, never mind, I'm out. Along the lines of contracting, sorry, I'm taking stage direction here. I don't take direction well, you may have noticed. That's why he's having to do that over and over. Like, I already told you not to walk over there. Oh, look, you're walking over there again. Work with me here. He's working with me. You guys just have to be patient. If you are signing that contract, you need to read it. You need to know what's in it. Think about things like, when do I get my rights back? If with a publishing contract especially, sometimes it says, well, if the book is out of print for X period of time, then any rights that we had come back to you. Well, okay. In the world where we had print, that made a certain amount of sense. It's still in a lot of the contracts. But when is a book out of print if we have print on demand? When is a book out of print if it's ebooks? If I took it off of Amazon and didn't allow it to be sold, then arguably be out of print. But what if they just leave it up there, haven't sold one for 10 years, and I say, well, I get my rights back. Oh, no, it's still up there. I mean, we haven't promoted it. We haven't printed one. We haven't actually thought about you. We thought you were dead. But the contract is going to continue. So read the contract. Know what's in it. Because that's where the law is going to make its decisions, based on what you agreed to, not on what's in the code. Okay. Copyright, we started with original work of authorship, fixed and tangible medium. Fixed and tangible medium is important because tangible medium counts your computer, so you don't have to actually use paper. Those of you who don't remember typewriters or word processors or pens and paper, I'm just going to grab some Geritol and be quiet, but writing in your computer counts. Anything that's not split second, basically, counts, and your copyright attaches at the moment of fixation. When you finish writing it, when you finish drawing it, when you finish carving it, whatever it is, once it's fixed in a tangible medium, it is protected by federal copyright law. This is not the way it used to be. Many of you have still heard that if I don't register it, if I distribute it without a copyright notice, a lot of things like this, I'll lose the copyright. That was true before 1978. It is no longer true. So you get automatic protection. However, if you care about this work at all, register the copyright. Do not rely on that automatic protection. The automatic protection is true, and it exists, and your copyright exists from the moment of fixation. However, you can't meaningfully sue on it until you register it. And there's a lot of cases of people saying, oh, well, let's hurry up and register it so we can register it before we file, but we got to file next week before it, And there's lots of cases of, well, if the registration comes through before the court reads the brief, don't be one of those. Do you know how much money you're paying your litigator to fight over the detailed timing? You don't want to do that. I have some friends who are litigators. They've got enough money. Don't give them more. They're already pretty cocky, kind of like the surgeons of the legal world. Beyond that, you won't get to sue for most of the more valuable damages. Your recovery is going to be very limited if you haven't registered it before the infringement happens. So don't worry about all those details. Let the litigators and me get excited about those details. What you need to remember is when you're done, register it. End of discussion. Now, any photographers? Okay, any people who write poetry or short stories or something that you're going to have a lot of? Because it's easy for me to say when you finish the novel, register it, right? And the registration is not expensive. Unless you do photographs and you shot 300 of them yesterday. $60 to register your novel, that's great. $60 per photo, oh hell no. So if you have a bunch of smaller works, like photographs, like poems, even and short stories, put them together, call them one work, and submit them that way. There's different boxes to tick on the application. It's fairly straightforward. You can do this yourself. Here's the one fact you've got to know exactly correct. Write it down. Copyright.gov. This is the place you go to register your copyright. Not hard to remember, copyright.gov, but the .gov part's important. If you're like me and as soon as you hit the period in an email, you write com without realizing it because your fingers get ahead of your brain. If you don't go to copyright.gov, you're not going to be at the correct website. Some of the sites that you get misdirected to are legitimate in that they take your money and they do register your copyright. But then you're talking hundreds of extra dollars that you really don't need to spend. If you want to waste several $100s registering copyright, call me instead. But I'll at least do it right. You can do it yourself. Honest to God, you don't need a lawyer. Go online to copyright.gov. It is a subset of the Library of Congress, and you can go through the application process by yourself. There's also a helpline that you can call. I've had people say, oh, I always just ask ChatGPT. I'm like, oh, good God, please don't. Remember we started with some things on the internet aren't true? Well, I mean, many of you are more technically inclined than I do. You know the fact that AI hallucinates. They had to come up with, well, a perfectly good word that we all use already to apply to the fact that AI makes stuff up. Great. Yeah, don't rely on that for something that's important. Go to the government line, call the help desk. The lawyers there are very helpful. If you say, okay, it asks if this is a compilation or if it's call them and ask that question and they will answer it for you so you can get through the application. If your work is a little weird, they'll help you with it. They won't give you free legal advice, but they will help you accurately fill out the form. And they're really good. And they don't hallucinate. They know the actual answer. And I would say that they're free, but I majored in econ. You've already paid for them. This is prepaid legal service in that you paid your taxes, you've paid for them. Call them and use what they know because they're very good at it. And the application changes from time to time. I swear each time I go through, they make it more annoying. But it's about $60 to file it. If you have to do a rush to get it in time for a lawsuit, it starts at $800. File when you're finished with your work. Now, when I say finished, I mean you're done. This is what you're going to submit. This is what you're going to publish. If an editor gets a hold of it and says, oh, we need to tweak this, we need to fix this typo, we need to move a few things around, that's fine. You don't really need to file the next version of it. If you substantially change it, file the new version. A few changes aren't going to matter. Substantial revisions, so it's almost a new book or a new work, yeah, that's what you're going to want to file again. Technically, it will be a derivative work of your first one, but since it's a derivative of your own work, perfectly legal, protection's all there. Okay? File your copyright when you're done. File it yourself, file it at copyright.gov. It's not hard. People screw it up, but it's not hard. You guys can do this. If you're trying to file a trademark, it's a lot more complicated. You can do it. You will pound your head against a wall from time to time. The helpline at the trademark office is still helpful, but they speak a different language. So you may find that too frustrating and you actually would want a lawyer. That one can go either way depending on the individual. Patents, other end of the program, you need a patent lawyer. So we're talking about copyrights. That's the easy one. Do it yourself. Questions so far? Yeah.
we can copyright things that are put in the tangible media.
Yes.
The costume tangible media.
Are what?
Costume.
Costumes are actually very interesting because you cannot actually copyright one at all. For some reason, when I talk about creative expression, and if you're doing something creative with your clothing, let me step back. Fashion design is not protectable. So I am wearing no designer labels whatsoever, but if I were, that designer would not have the rights to my generic drapey black blazer. But what you might have a right to is a fabric pattern. Gentleman up here in the front, you're behind the camera. Stand up. Everyone look at you real quick. See this funky pattern on his shirt? That pattern could be protected, but the shirt itself is not. So fabric design, or, oh, say, thank you. I'm just going to leave you there for 20 minutes. For instance, hypothetically, if you've been to, I don't know, the Marriott, where they had a carpet, the pattern of that carpet.
And they tried to sue.
Oh, they didn't try, they did.
They did.
That pattern of that carpet is owned by the carpet company. That textile pattern is protected. That pattern, because it's in a carpet, no. That pattern in a tote bag, the tote bag's irrelevant. The only thing there is the carpet pattern, the fabric pattern. So that pattern put into clothing, the clothing is considered useful. Even if it's a ball gown or a Star Trek uniform, which is distinctly unuseful. Long sleeves and barely covers your butt. Seriously? But I'm sorry. It's my own issue. So clothes are considered useful. Textile patterns can be covered by copyright. Clothing is not. Costumes occasionally can be if it is something that does not serve a useful purpose. Now, this is where some of the cases kind of go awry. There are dueling banana cases. I'm a costume that makes you look like a giant banana. There is one case saying that's just stupid. No, I mean, that's not useful. Therefore, it is an unuseful design. Therefore, that costume can be covered by copyright. A similar case of identical as far as any of us are concerned, banana costume said, no, that's still like clothing. It's not protectable. So there's a line where it gets fuzzy and there's not a strong answer. Those little noses that were popular for a while, you had little rubber bands that held a pig nose or a wolf snout onto your face. Those have no purpose whatsoever. So those will be protected by copyright. The little ears, those don't serve any purpose. Although people have argued if they're on a hairband, since it holds your hair back, it might be useful. And then when we go into distinguishing between which part of a costume or a piece of clothing is useful and which isn't, I make my students cry with that exam question. So it gets really murky really fast. There was a recent Supreme Court case where all of them spent an awful lot of time looking at cheerleader uniforms. I'm just going to leave that there. And it was supposed to clarify the law on this. They stared at the cheerleaders for too long, as best I can tell. Their brains scrambled. They tried to clarify, they did not. So I have nothing more clear from that. But as a general rule, costumes are not going to be protected unless it's a specific part that has no useful part whatsoever. Does that sort of answer what you wanted to know?
Yeah, I think it's more important.
Okay.
Pictures of a performance or another artwork, is the copyright retained by the original artist, or is the photographer holding a copyright of the image?
If I take a picture as the photographer, I own the copyright in that photograph. However, if I take a picture of a painting that is currently under copyright, I am infringing that painting by making an unauthorized copy of it.
And of a performance?
A performance, if the performance is being recorded. This is a stupid copyright rule. This is the sort of thing that my students get wrong on exams. It's kind of fun. If the performance is being recorded, then it's being fixed in a tangible medium. If the performance is not being recorded, it's not fixed, so there's no copyright. But if you take a picture of a copyrighted performance, you are infringing that performance unless you have permission.
But it's the person who fixed it who owns the copyright, not the performer.
The person who owns the copyright of the performance, usually that'll be the script writer or the production company, whoever owns the performance is the one who owns the rights in that performance. If you take a photograph of that performance, you're infringing their copyright. But if you take a photo that's not infringing someone else's copyright, the photographer owns it. The subject of the copyright, if there's no, the subject of the photograph, if there's no copyright involved, does not own the photo. There have been cases where paparazzi have sued celebrities because the celebrity sees a picture that was taken of them when they were out in public, legal photo, no copyright, no right to privacy, perfectly legal photo. The photographer owns the picture. They posted it. The celebrity said, "Oh, I look so cute in that picture," and posted it on their own social media and get sued by the photographer because them posting a picture of themselves infringes the copyright of the photo that's held by the photographer. See how simple this is? Yeah.
So we talked about fashion, copyrightedness or not on that. So, but you're saying the design of it, because I do screen printing.
Mm-hmm.
So the design is what gets copyrighted, that regardless of what type of apparel it goes on to, like if it went to
Yes.
short sleeve, long sleeve, it's singular copy.
The copyright is the artwork.
Okay, and then the more complicated question is, if things have already been like, ripped and yoinked and sold elsewhere, but then you copyright it later, I'm assuming you can't just backtrack to something they did prior to you having copyright. Or is there ability to do that?
You can, you won't get much money for it.
I mean,
And you certainly you certainly would be able to, if they're copying your design without authorization, you certainly would be able to get at least an injunction against them continuing to do it. If you hadn't registered it when I told you to, that if you didn't do that, you can still, as long as you register it before you file a suit, you can still do that. But you won't be able to recover damages for that, but you can at least keep them from doing it again.
That's mostly, yeah. But the not the third question, but it comes from another country. What's the?
Oh, good luck.
Yeah, how does that work?
Technically with the copyright conventions, the Berne Convention, most first world countries all agree and enforce the law, and the law that the rights that you have in another country that has signed the Berne Convention, basically, this is a real broad brush, are going to be the same as anyone in that country, but suing someone in a foreign country is difficult and expensive, and if they're in China or India, yeah, good luck, because some countries just don't enforce rights. You have a question?
Yes, I'm a professor like you, and when we create slides, right, and other materials to give out to the students, is that copyrightable?
That is an excellent question because it gets me to
Yes.
something I need to point out.
Okay.
The idea of a work made for hire. If I create a work, we started with I write a book. Okay, I'm the author because I wrote it. So far, so good. If a monkey takes a selfie, hypothetically, or if an elephant paints a painting, no copyright. Author has to be human. We've known that for a long time, which is why copyright lawyers weren't confused when AI came out. We know that anything written by AI, anything that AI generates, is not going to be protected by copyright because AI is not human. So only a human can hold a copyright. So far, so good. But what if one human working for another human, or a corporation or a school or whatever, but I'm a human, I created these slides. Now, you know that you don't own the facts in them, but the way you did the slide and the meme you added on the side and all of the stuff you did, you own that. The general rule is if you are an employee and you create something that will at least even partially benefit your employer, and it's kind of the sort of thing you're paid to do in the regular scope of employment, you don't own it, your employer does. That's a work made for hire. If you're an employee and what you created is close to what you're paid to do, it probably belongs to your boss, to the company, not the individual, the company that you work for. Now, there are exceptions to that. If I'm a bricklayer and I write poetry, the construction company does not own it. There are some rules that we used to look at, like whose equipment do you use? Was it during your, was it done at work or at home? And those are becoming less and less helpful because, I'm sorry, when are we not at work? They can reach us now, even when we try to get away. So when am I at work? When am I not at work? It's better if you don't do it in your office at work on your employer provided computer, but that alone is no longer really determinative. So figure out if it's too close to something you're doing for work and you want to own something that you're going to create, get an agreement with your company. Say, hey, I want to create this. I want to use it with work. I want to let you use it, or I want to quit and have you pay me as a consultant. Probably don't tell them that up front. So let's agree that I own this. If you all agree, get it in writing, then you're fine. Now, professors are different. Technically, what you just described to me, absolutely, the school would own it. However, when professors write stuff, we own it. I don't know why.
Okay.
The law doesn't really carve this out, but the case law is very clear. I've always assumed that if I'm a professor, and if I were a full tenured professor, I'd be churning out these long, boring academic articles that no one reads. No one wants to own those. I assume that's why they let me own them. But if I were a professor of some sort of useful science and I created something patentable in my lab, the school probably owns it and probably will give you a small cut of it. Some of that's going to depend on your agreement with your school, but patent rules are different than copyright rules. So the articles that academics generate, the school does not own. The slides you generate are a little closer, but you probably own those as well, because the professors kind of have their own carve out. Anyone else who made slides for a presentation they're doing at work, your boss owns it, not you.
But as a professor, we teach at different schools or we have our own thing. And if I present that to the school, can they take it? I had an incident when they told me to take my name off.
That's going to depend in large part on the school. Now, if you're at a traditional university like Emory or UGA, they're not going to try to claim that crap. But if you're at a for-profit school or one of the, sort of accredited but not really accredited schools, I turned down a job with one of them when I kind of needed the money. I was a single mom and needed some extra money on the side, and teaching for one of their programs would have been great. And they gave me a contract that said everything I wrote was theirs. And I said, no, I write lots of things.
Right.
You don't get to own them because most of them I'm going to publish somewhere way better than you. Right. You're just here to feed me. Now I was willing to tell them any lesson plans I create for your classes, okay, you can own those. Anything I'm doing for you, yeah. But we're going to carve out everything else I write. And I thought that would be fine because that's very standard. Yeah, these dirtbags said, oh, no, we can't do that. Well, first they pretended they didn't know it was in the contract. Then they said, well, you would have to talk to the general counsel about that. I'm like, okay, bring it on. I've been a general counsel. I'm not scared of talking to one. And then I spoke to the general counsel who told me, and I quote, we will never enforce that. Yeah, I'm like, I do this for a living, right? And I did not then teach for a school. I ate more ramen, less meat, and did not work for them. So look for what the agreement says, because they will sometimes screw you over. The traditional rule is not always enforced, and if your contract says they own it all, well, guess what? They own it all.
Even stuff you already produced. Sometimes you get hired, like you have your copyright 101.
Yeah.
And the school says, oh, we want you to teach that over there. Mm-hmm. And you bring your materials over there. They
wouldn't have a right to that.
Right.
Unless they say in a contract with you, anything you present becomes theirs.
Oh, okay.
Watch the contract.
Yeah.
And especially some of the for-profit schools, they've got some pretty slimy contracts.
Yeah, they are.
Like I said, I turned them down because they wouldn't negotiate it. Okay, yeah.
So I have a question about starting a business specifically when you're talking about creating a name. Is that more of a trademark?
That's a trademark thing. Either let me answer it afterwards, or if I have time, I'll get to the trademark stuff. Yeah.
For articles and beyond, what are the, like, if it's made in 1900 or whatever, what are the rules for reproducing it,
Okay, duration of copyright. Let me answer that, and then we're going to move to a couple more topics, and then I'll take some more questions. Copyright lasts currently for the life of the artist plus 70 years.
Ooh.
So if I write something today, the copyright will expire 70 years after I die. I wrote things 10 years ago, the copyright on those will expire 70 years after I die. But wait, I hear you cry. You talked about Mickey Mouse, and the early Mickey Mouse cartoons are in the public domain, and the later Mickey Mouse cartoons aren't. That doesn't sound like what you just said. Well, the early Mickey Mouse cartoons were created before January 1st, 1978. That's your first big cutoff date. The 1909 Act was in effect up until January 1st, 1978. On January 1st, 1978, the 1976 Act went into effect. Thank you, Congress. That was efficient. So the 76 Act, which takes effect January 1st, 1978, changed the whole way we do it. Until 1978, copyrights lasted for a period of about 18 years, and then if you filed to renew it, you got another 18 years. As we got closer to 1978, some of those periods extended a little bit, and then they changed a lot after 78, just enough to make it bloody near impossible to figure out if something from the 30s or 40s or 50s is currently covered by copyright or not. It's also a fabulous exam question for my students because I can make blood come out of their ears. It's wonderful fun. So that can be a very complicated question of whether some of the old stuff is covered or not. Some of it, and the year that is the magic year, keeps changing every year, and I keep losing track. It's like 1928 or 29 is where we're at right now. Everything before that date is absolutely in the public domain. It cannot be covered mathematically, no matter what happened in between. Later things might or might not be covered, and it's very hard to go back historically and figure out both who owns the old copyrights, whether they filed successfully for renewal, because if they didn't file for renewal, it will be in the public domain because it would have fallen in there about 18 years later. And copyrights then ran from the moment of publication, the exact date. Now, copyrights start and end on January 1st, like racehorses, same birth date. So if you were a magazine writer in the 40s, you were publishing articles all the time. If you owned the copyright to them, or even if the magazine did, each publication date is when that copyright started. Good luck keeping track of that. So there's a lot of smushy we don't know about earlier works. Sometimes you can tell, sometimes you can't. And that's one of the things that drove Congress to change to what we have now, which is it starts when you create it, it ends some number of years after you die. All of the things you create end the same date. Much easier. So in 50 or 70 years, we'll be able to tell exactly what's in and out of copyright, but the earlier stuff, it's hard to tell. But so the duration of copyright, and we talk about the specific rights, we talk about authors, we've gone through those sorts of things. Give me 1 second to look at my notes and see what else I was supposed to tell you, because I get excited and I change the order we talk about things. We did expression. Okay, good enough. We talk about fair use. Whether we want to or not, we got to get that. Fair use, how many of y'all have heard of fair use? Yeah, everyone. Most of what you know is wrong. Most of what you read makes it sound like if you're changing the original work, you're transforming it into something new that serves a different purpose, then it's a fair use and it's not infringement. Well, that's really cute. Do you know where the phrase transformative or transforming the underlying work actually appears in the statute? Not in the section on fair use. It appears in the section that defines derivative rights. And remember, the right to make a derivative is the author's right. So the right to make a new work that transforms the old work actually is an exclusive right held by the author. And yet, we use that same concept to define something that you're allowed to steal without permission. Gee, that's not confusing, is it? the results of lawsuits in fair use are all over the map. I can tell you whether something should be a fair use under the law. I can look at the statute, I can be aware of the valid cases, and I can tell you with fairly good certainty, any fact pattern you give me, I can tell you whether that really should be a fair use or not. God only knows what will happen by the end of your case, however. But one important thing to know from a practical standpoint, because if you get another academic up here with me, we can get into a bloody battle. We know who I'm talking about. Into a bloody fight over whether something is fair use or not. What matters for you guys is something very important that most of the fair use advocates don't tell you. You don't have an independent right to fair use. By walking around as a citizen of the US, you have free speech rights, free association rights, right to remain free from unreasonable search and seizures, all kinds of good stuff. You know what's not listed there? Fair use. Fair use is an affirmative defense to an action for infringement. Lawyers like big words. What that actually means is fair use doesn't even become relevant until you've been sued for infringement. You know what happens when you've been sued for infringement? You need a lawyer. Now, if you have enough money to pay for a litigator to defend you in a lawsuit, then by all means, take a reasonable guess at whether the thing you want to do is a fair use or not, and go for it. If, on the other hand, paying someone between $600 and $800 an hour to defend you against a lawsuit would be difficult, maybe just don't use people's stuff without permission, because a lawsuit for infringement is expensive. And it's not like you can choose whether to be involved or not. If you own a copyright, you can choose whether to sue to enforce it or not. If someone's suing you, you don't get to say, oh, no, I don't want to be in that lawsuit. That's not how it works. And you got to get a lawyer to defend you. And that's not fun. Now, again, if you can afford that and you feel strongly, by all means do it. That's why we have the court system set the way it is. But the phrase, how much justice can you afford, is very real for most people. And if you're creating and you don't want to be sued, don't use people's stuff without permission. Even if you say, oh, but I'm transforming it. That even what the courts tells us, that's not enough. Okay? It's part of the discussion, even though it's confusing, but it's not determinative. That's not enough. You need more. And the details of that are more than we have time to get into right now. The important thing to remember is if it's not carved out expressly in the statute, and the things there are very limited, and they're not even that reliable. Fan fiction, fan art, it's infringement. Now, not all content holders are going to sue. And if you're just doing this to amuse yourself and your friends, the reality is they're never going to know. One of my girlfriends and I wrote a absolutely fabulous, I assure you, we didn't call it fan fiction at the time, but that term didn't exist, but Star Trek existed, and we wrote a Star Trek fan fiction script. Oh, it was brilliant. We were in 7th grade. You could tell the part where we went and saw the movie Airplane, because suddenly there were a bunch of jokes. Space, what is it? Well, it's 4 non-collinear points, but that's not important right now. It was pure literary gold, I assure you. Paramount didn't care, because the only people who knew about it were my parents, who, bless their hearts, are willing to type an extra copy for us, and a few of our friends who we trapped in the basement and made them read through the script with us because we thought it was fun, and they realized they couldn't get past us to the exit. So Paramount didn't care. We were happy. Did we infringe? Hell yeah. Did it matter? Absolutely not. So can you get away with it? Yeah, probably. But if you're actually putting it where someone might notice, it doesn't matter if you're selling it or making money. Okay. If you're putting it where someone might notice, you might get sued. And whether or not you really have the right to use it the way you used it isn't going to be clear until the judge says so, and the judge doesn't say so until the end of the trial. For most people, relying on fair use is dangerous, and it can be disastrous because it can be all of the money you have to defend yourself. And I don't like leading people into thinking, but I have the right to do this. Yeah, maybe, but you're going to get sued into bankruptcy. So it's a risk. It's not evil, it's not immoral, but it's a real risk, and it's one you should consider before you rely on fair use. That's also the reason that all of these bazillions of AI suits, I represent some publishers and authors, and they're all following each of these suits. Oh, Anthropic got sued, and the judge said something. Now, first off, all of these results that come out every other day, they're preliminary. We have 3 or 4 levels of appeal at least before anything even matters from those cases, because those people aren't going to stop. That's going to be appealed until someone dies or the Supreme Court determines the answer. And the facts on each of those fair use cases are so specific. Again, there's a whole class I could do on those. Trust me when I say each one of them is so independent that it's not going to make a difference to the results of the others. We're not going to get an answer to whether scraping is fair use or not from the courts. It's just going to take too long and be too fragmented. The only answer is eventually going to come from Congress on a pragmatic level. That's because these cases aren't going to settle anything. So if you have friends who are excited because this came out and heartbroken because that result was bad, yeah, there'll be another result tomorrow. And none of them are going to coalesce and be decided unless the Supreme Court wakes up and decides to take a whole lot of cases suddenly and combine them and make a useful holding. And that's happened, to my knowledge, never. Could happen, probably won't. Okay, we have like time for 1, maybe 2 questions. But like I said, if others of you have questions after we're done, we have to give the room to the folks who are coming in, but I can answer for you outside. Yeah.
If I'm in the middle of a work, is it better to get the copyright while in the middle of it or at the very end?
When you finish. Unless it's like 2 individual parts or something, but the general rule is, since you are already protected at fixation, each word as it comes up technically is going to be protected as it comes, but you're not going to be showing it to people until you're done. So when you're ready to show it to people, when you think you're done, file it then. Yeah.
If you're working with a colleague on some works together and you part ways after many years, you rework those works to make them your own, or who owns these 50/50?
It depends. This is the best lawyer answer ever. I teach it to all of my students because all lawyers and law students learn that word. It depends. Always the best answer. Also gives you time if you need to think about an answer. But it really is going to depend on the facts of the situation. If you worked on something with someone else intending to create a work together, and your intention at the time was to create one work, then you guys are considered joint authors, and you each have an undivided right in the whole work. Well, now you're not speaking. Did you sign an agreement?
No.
Probably not. You should have. But always sign an agreement while you guys still agree on everything. Figure out what's going to happen if one of you didn't want to finish. Figure out what's going to happen if you disagree before you disagree. While it's still a hypothetical fight, you can usually come up with what seems like a fair result, agree to it, and write it down. Even if you don't have a lawyer writing your contract, you should. I'm much better at it than you are. But if you will use simple grammar and complete sentences and write down all of the things you can think of that could go wrong and what will happen if they do, and you both sign it, you're in much better shape than if you don't. It'll be better if I draft it for you, but again, I'm expensive. So
Are you taking money from it?
oh yeah, absolutely. Here's my pitch. You don't have to buy my book, hire me. But if you can't do that, write your contract. But if it's worth hiring a lawyer, absolutely, I do. And don't hire a litigator. They're really good at litigation. They think they can draft contracts. They're wrong. I know I can't try cases. They seem to think they can do my job. But if you already have split ways and it's too late to make nice and have an agreement, it's if you take the ideas of that work and rewrite them completely.
Or re-record them?
Probably. It depends what you're recording. If you're recording something the 2 of you wrote, any expression that existed as part of that joint work is always going to be a joint work. You can do things with it, but you'll have to send him half the profits. But if you want to just start over, think about those things that aren't protected by copyright. The facts, the ideas, the processes, any of that functional stuff underlying it, you can still pull that out and write about it or record about it or whatever again, as long as you're not copying any of the expression from the original work. and talk to a lawyer probably, because if you make money, your original author friend is going to show up. Do we have time for one more, or are we out?
You can do one more.
One more. Yes, in the back.
Can you speak up, please?
If the right to publish is, she's asked what happens with a novel that you write that you self-publish. If you're self-publishing it, you're not having to give away the publishing right to a publisher. However, be careful, because most self-published works are now on Amazon or somewhere like that. Before you upload your work to Amazon, read that agreement, because you are giving Amazon some rights. Now, you can't negotiate with them for a better deal, so at the very least, make sure you're aware of what rights you're giving away, because although you're not making a formal agreement with a publisher and signing a publishing agreement, clicking I agree is also an agreement. So even though you're self-published, you're still giving rights to Amazon. Read the agreement to make sure you know what you're giving away.
We can
And
do
that's
one more.
one
Are
more.
you good?
I saw someone on the back, yeah. And then the rest of y'all, seriously, I'll talk to you outside, yeah.
Can you speak up, please?
I'll repeat it.
Fan fiction is obviously a copyrighted segment, but if you were doing like a podcast or something like that where you were talking about book and story, does that get into the?
Excellent question. She was asking if if you write fan fiction, it's an infringement, but what if you're doing a podcast and you're talking about a work? That actually is one of the few things that is reliably fair use. I can talk about a book that I read on my podcast. I can say that I hated it. Criticism and critique is one of the real, just absolute heartstones of fair use. I am allowed to say, I read this book and it sucks. And I'm allowed to take small excerpts from that book to prove how much it sucks. Now, some of you have heard rules about you can use 5% or you have to change it. Remember what I said about patent lawyers in science and me and other lawyers in math and science? We don't do numbers, we don't do math, we don't do science. If there's a number in this rule that you heard, it's not real. So if you need to cite a paragraph out of a novel, yeah, go nuts. If you want to say, look how horrible this author's grammar is, look at these ridiculous things this character said, and you use a very small excerpt to show what you're saying, that is, honest to God, fair use. You will not be sued. And if you are sued, it'll be dismissed immediately. That is one of the few things that's reliable. I can talk about a work. I can mention the author by name. I can mention the book by name. I can talk about what happens in the book. I can quote small pieces of the book for the purpose of criticism and critique, not for the purpose of getting people to watch my podcast because I'm going to show big long clips from a game and they want to see the big long clips from the game. Okay? You guys know the difference. It takes juries and judges a long time to figure it out. You know the difference. If you're really just using an excuse to show some stuff so people will watch your video, watch your podcast or your TikTok, no, that's not fair use. If you're writing a critique of the book, a review of the book, you are actually, it's one of the few things I will say you're safe in fair use. Okay, a lot of y'all have some other questions. I'll be outside in just a sec. I'll be happy to answer them.